Good morning. My name is Chris Ritchie, and on behalf of Huntington Bank, I want to welcome you to the final day of our 4th annual Class Action Money and Ethics Conference. Yesterday, we had terrific panels on antitrust, ERISA, labor and employment, and securities. And today, our first session will discuss no injury class actions. Then we'll have an ethics panel on protecting data in class actions. And our final panel will be on climate change, which is top of mind right now for many of our participants on the West Coast. We want to thank our presenting sponsor, the Beard Group, and our supporting sponsors, Alert Communications, Broadridge, CPT Group, Dundon Advisors, Pacer Monitor, and Top Class Actions. This conference is being recorded. Our colleague, Colin Post from Beard Group, will email Zoom links with a password to access the recording. Also, on our website, classactionconference.com, you will find background materials for the panel discussions. During these panels, we really encourage you to submit questions by using the Q&A icon you see on the bottom of your screen. Please pose questions. It makes the program much more interesting for both the panelists and the participants. And shout out to Barbara Hart from Lowy Dannenberg, who submitted provocative questions to more than one panel during our prior sessions. Now, let me introduce our conference co-chair, Jeff Clank, Director at Berkeley Research Group, who will introduce our first panel. Jeff?
Thank you, Chris. And let me start off my remarks this morning just by thanking you for all of the work that you and your colleagues at Huntington have put into this conference, Chris. Without you, this conference would not be of the quality and caliber that it is. And let me also say that I've really enjoyed sharing remarks with you in the mornings, Chris. So thank you so much, and thank you so much to Huntington. For those of you who have been with us the past few days, you know that a recurring theme of this conference, and one that I've emphasized, is that it really seeks to bring together opposing viewpoints. It seeks to bring together those that predominantly practice on the plaintiff side, as well as those who predominantly practice on the defendant side. And as opposed to some other antitrust or class action conferences that many of you may attend, hopefully you will find this conference to be very different in tenor, in that it isn't a plaintiff conference and it isn't a defendant conference. And that's what makes this first panel coming up so compelling. Not only is it moderated by my good friend and colleague at BRG, Robin Cantor, but it also brings together what I think will be some very different viewpoints on the idea of no injury at class actions. And I think the panelists that we have both are great representatives for their particular viewpoints. So let me go ahead and introduce my friend and colleague, Robin, to you. Dr. Cantor is Managing Director at BRG, and she specializes in applied economics, product liability, damages analysis, class actions, and complex litigation. And Robin is also the co-lead of this class action conference. She is also co-lead for class action litigation at BRG. Dr. Cantor has her PhD in economics from Duke University with a specialization in econometrics. Robin has been engaged equally by plaintiffs and defendants on more than 30 class certification and mass tort matters involving diverse consumer, commercial, and industrial products and services. She joined other prominent economists and social scientists in an amicus brief submitted to the US Supreme Court in Tyson Foods regarding the reliability of average or statistical evidence in class actions. Robin co-chaired the Class Action Money and Ethics Conference in 2018 and 2019 in New York City with me, and has worked with me to co-chair this current conference. So let me turn over the microphone to Robin to get this panel started. Thank you.
Robin, you're on mute.
Okay, thank you. I didn't see my picture yet, so I wasn't sure if I was up. Okay, I think people can hear me now. So welcome everyone. I want to say good morning, good afternoon, and maybe we even have some people that are good evening. We probably have people coming into this from all over the world, and that's really wonderful. I also want to express my thanks both to Chris and Jeff, who have just done a terrific job getting us going every morning. And this has been a real experience. I feel like I've learned so much about running a virtual conference. This is great. I'm going to put this as a qualification on my CV. Today, we've got this really terrific panel that you can see various folks. We're going to be doing this in the panel display mode. And we're going to be talking about these no injury class actions, which, you know, even though it's not a specific area like antitrust, but it goes across a number of different areas of litigation. And I think the whole issue of no injury class actions is so important and is definitely an emerging issue. Today, we're going to hear things about how standing comes into play, how due process comes into play, and also predominance, which of course for many economists is a central issue. I also do want to encourage people to ask questions, use the Q&A and ask questions. I will definitely be monitoring that. And I'm just looking here. Okay, so somebody said, please use the Q&A for that. Good. And so let me just get this started. What we're going to do is the panelists will have a certain amount of time to give you their prepared remarks. We are also going to be doing some polling, which is such a great fun thing to do in this process. We'll do polling during their prepared remarks, and then we will give the panelists an opportunity to respond to each other because there are diverse viewpoints on this panel. And then we will address the questions from the participants. So with that, I want to introduce the panelists briefly, but I do want to encourage everyone, please go to the website. The bios are there. You can take a look at that. These folks are really accomplished, and I want to make sure that their information is shared with all. But I'm going to start with David Kalat, who is a director at BRG. He's a testifying expert in information science and electronic evidence, and he leads the Chicago Digital Forensics Lab for BRG's Global Investigations and Strategic Intelligence Practice. Here's the most interesting thing about David. He's got lots of experience in digital video, all of this information, but what I found most interesting is that he is a licensed private detective and also a nonfiction author. So I wish we could be at a cocktail party afterwards and find out information about that. He has a master's degree from the University of Illinois. Our second speaker is going to be Michael Daly, and he's a partner with Drinker, Biddle, and Reath. And his practice focuses on defending class actions, handling critical motions and appeals, and maximizing the defensibility of marketing and enforceability of contracts. And I love this term, Michael, that you're an authority on aggregate litigation. I'm going to be using that term going forward. I think it's great. He often speaks and writes about many important developments in the law. But again, a really interesting thing about Michael is that he is a champion for civil rights and civil justice, and his public interest work has protected the rights of the disabled and the incarcerated and prevented the misuse of the legal system. So, you know, again, at a cocktail party, I would love to hear more of that. He's a graduate of Bucknell University and Villanova University School of Law. And then our third panelist is Eric Kramer, and he's chairman and co-chair of the Berger Montague Antitrust Department. And he has a national practice in the field of complex litigation, primarily in the areas of antitrust class actions. And most recently, he's focused on representing workers claiming that anti-competitive practices have suppressed their pay. And again, a very interesting point about Eric is that this is on behalf of mixed martial arts fighters and chicken growers. And again, I would love to hear more about that. He's a recipient of many, many awards. And again, please go and look at this bio. Many awards for his contributions in the legal field, and he's a frequent speaker and has published widely on class certification in antitrust law. And Eric is a graduate of Princeton University and Harvard Law School. So with that, I'm going to turn it over to our first speaker, who is David. And David, your remarks.
Thank you, Robin. So there are a couple of different ways that we could be thinking about what it means to be a no-injury plaintiff in a class action. Eric's going to be exploring this conversation from a different direction. But we'd like to start the panel by looking at what it means to be able to show up in federal court with a standing to state a claim. So what we're talking about here is Article 3 standing, and the key piece of precedent framing this issue is Spokio v. Robbins from 2016. Now, for those of you who aren't familiar with the Spokio case, just to set the table for you, Spokio provides online background checks aggregated from various data sources. And in the case of a man named Thomas Robbins, the report on him had some errors. But here's where it gets interesting. The errors were that it claimed he was married, he had children, he was employed, relatively affluent, and held a graduate degree. So while the information was inaccurate with respect to him, it wasn't obviously defamatory or harmful. Nevertheless, he pursued a class action alleging Spokio's errors violated statutory requirements under the Fair Credit Reporting Act. Now, Robin, we're going to throw up the first of our poll questions here. And this isn't meant to be a trick question. I'm just curious how your instincts align with where the court ruled. So if we can put the poll up. I know that many of you already know how the Spokio case turned out, or you can guess based on the topic of this panel. But just to give your own answer, was the plaintiff not entitled?
I'm sorry, David. I hate to interrupt you, but are you seeing the poll?
I'm not seeing it, but I don't know if I would.
Okay,
I think I saw it during our tests. There we go. It is up now. Okay, awesome.
Yes, but it's yes. Okay, go ahead.
It's there. Yeah, thank you. So as I said, this is not meant to be a trick question. And I realize that some of you already know what the actual answer that the Supreme Court came out with, but I'm curious what your responses are. Do you think that the fact that Thomas Robbins wasn't directly injured means that he doesn't have standing, or is the fact that the Spokio report violated the technical requirements of the law was itself the violation? And we'll go ahead and leave that up for a little bit.
Well, I think that now the results are up.
Everybody, looks okay. Let's see what that came out to.
Can you see the results?
Well, it looks like the majority of people said that Spokio actually has an obligation under Fiegre to ensure accurate reporting. So you're coming out the opposite of the way the Supreme Court ruled. That's interesting. So anyway, as you can guess, the Supreme Court ruled that Article 3 requires plaintiffs to establish a concrete and particularized injury in fact, not just plead statutory violations. And in the aftermath of that decision, where this happens to come up with some regularity and has produced some circuit-splitting differences of opinion is in cases brought under the Telephone Consumer Protection Act, or the TCPA, because that law provides statutory damages and a private right of action. Now, interestingly, some of these disputes about whether an injury in fact can be established varies depending on technological matters. And that's where I come into these cases because of my role as a testifying expert on electronic evidence. So, for example, as far as the TCPA is concerned, text messages are a form of telephone calls. But the standards of how many unwanted text messages counts as an injury versus how many unwanted phone calls shows the courts do actually perceive a difference between these technologies. So there was an 11th Circuit ruling in a case called Salcedo versus Hanna that found that the receipt of a single unwanted text message did not rise to the level of a cognizable injury in fact. But meanwhile, there was another case, Shookett v. Dial America, and the Southern District of California found that the receipt of a single, in that case unanswered, voice call was a concrete injury under Spokio. Now, of course, I should mention that there are contrary opinions for both positions in other jurisdictions, finding that a single text message was an injury or that somehow 100 voice calls was not. But the point remains that calls and texts are treated as the same until they aren't. And along those same lines, today, very few people or businesses still have physical fax machines. Instead, the trend is towards the use of e-faxes, where the fax is received as a PDF attachment to an email. TCPA doesn't regulate emails, and the injury associated with an e-fax is kind of unclear. There's no screeching noise, your phone line isn't tied up, you don't have your ink and paper used up unless you choose to print it out. And this past December, about a year ago, the FCC declared that the TCPA does not cover e-faxes. But whether you receive a fax as an email attachment or as an old school ink and paper screech baby is your individual setup and not something that's likely to be reflected in the transmission record. So there's this technological difference that can create havoc when you're looking for a common method of proof. And then there are things like the California Invasion of Privacy Act or Illinois' Biometric Information Privacy Act, where courts have tended to find that bare statutory violations can be deemed injuries in fact despite the lack of tangible consequences because of the particular nature of the cyber rights involved in those technologies. Now, another way that this issue comes up is in the form of the professional plaintiff. This is maybe an unfamiliar concept for some of you, but anyone who works in TCPA litigation has almost certainly come across at least one example. There are certain individuals who have been the lead plaintiff in numerous TCPA class actions and putative class actions, and some of them have explicitly made this their business. And the most famous example of this is probably the case of Melody Stoops. She brought a lawsuit against Wells Fargo for debt collection calls that she received that weren't intended for her. The bank was making these calls based on consent given by their customers to be contacted at the numbers that they'd provided, but some customers had then changed their phone numbers, so the calls were going to wrong numbers, such as Mrs. Stoops. What set this case apart was that Ms. Stoops admitted to purchasing literally dozens of cell phones from economically depressed areas with the expectation that some quantity would have been recycled from former users who would be contacted by debt collectors, and so she could file suits based on those wrong number calls. And the court found that that was not an injury in fact because of her expressly stated goal was to file these TCPA lawsuits. Importantly, though, the Stoops case is an outlier in many ways. The specific facts of her carrying around 35 cell phones in a cardboard box are memorably weird. And her admissions that she was seeking the very calls for which she claimed injury were well documented and under oath. Meanwhile, recurring plaintiffs frequently surface in TCPA actions without that kind of colorful detail and without the evidentiary groundwork that you would need to prove to a skeptical fact finder that the plaintiff was acting in bad faith. Instead, when this issue is raised merely on the basis that a plaintiff is a frequent plaintiff in similar complaints, courts don't generally find that to be a negative. This issue has been raised in several cases that I've worked on, and courts often find that a repeat plaintiff is in some ways better suited to be a class representative than someone new to litigation, and that they're serving a public interest in holding telemarketers to account. So while some professional plaintiffs in certain circumstances may be found not to have an injury in fact, this will end up being a very fact-specific inquiry. And I'm going to hand the mic over to my colleague, my friend Mike, and see what he has to say on the topic.
Go ahead, Michael.
All right. Thanks, David. That was a great introduction to what I'm about to talk to. Robin, why don't we go ahead and put the next polling question up, and I'll just talk over that while folks register their votes. Okay. So this fact pattern really isn't hypothetical at all. It comes from a real case. It's called Lesotho versus Mamma Mia out of the Southern District of Florida. It's about 10 years old now, so it's a little stale. Pardon the pizza pun, I suppose. But I picked it because it captures, in my mind, two defenses to no injury class actions that I think don't get nearly enough attention: superiority and due process. So for years now, the Spokio defense that David was talking about has really been the center of attention in the no injury class actions space. And other procedural defenses like superiority and due process have really been relegated to the back burner. And I submit that maybe, just maybe, things should be the other way around. So let's see how we're doing on the polls.
Okay.
Oh, this is a polarizing poll. That's great. So Spokio, the thing about Spokio, a couple things really. First, some courts are just hostile to it. And I think maybe it's because they think it was wrongly decided and they're pushing back on the Spokio case where they can around the margins. But whatever the reason, there are some courts where the Spokio argument is just not going to get the attention it maybe deserves. Second, Spokio is not a defense that needs to be asserted right out of the gates. Because it goes to the court's subject matter jurisdiction, it can be made at any time. It really can't be waived. And so there are cases where it's probably better and safer to make that argument after there's been a clear factual record that's been developed. The Stoops case that David talked about is a perfect example of that. Third, the Spokio goes to a court's jurisdiction. And so a dismissal under Spokio likely will not get you a ruling on the merits, a dismissal with prejudice, which means you're not necessarily assured of any finality. So for those reasons, I tend to view Spokio as sort of a last line of defense and think that defendants are better off focusing on defenses that result in a substantive win on the merits, for example, a lack of statutory standing, or in a procedural win on certifying a class or aggregating damages. And that brings me back to the facts of the Lesotho versus Mamma Mia case. The defendant in that case was a small mom and pop pizza shop. It was sued under FACTA because it had been printing too much information on its receipts. That really wasn't in dispute. But the pizzeria had no idea it wasn't supposed to be doing that. It stopped immediately once it learned it wasn't supposed to be doing that. And no one, the plaintiff or anyone else, alleged that their identity had been stolen, that their credit had been affected, or that they had really been injured in any way at all. And so the question, I think, is in a case like that, with an unintentional violation, with very quick remedial action, with no actual damages at all, and with statutory damages that are an order of magnitude more than the defendant's net worth, is certification the superior way to resolve the dispute? And even if it is, does it comport with due process? The other thing about the Lesotho case is that it really does illustrate that small businesses can get caught in the class action crosshairs. When we think about class actions, the archetypal dynamic is a lone plaintiff against a large corporation. In reality, though, the targets of many cases are small businesses, and they don't have in-house counsel, they don't have outside counsel, and they don't really track these sorts of compliance issues the way other larger businesses do. For those sorts of defendants, these really are bet the company cases, and it takes a lot of intestinal fortitude to fight them. So this conference kicked off a few days ago with Professor Fitzpatrick's conservative case for class actions. It was thought-provoking stuff. I didn't agree with a lot of it, to be honest. But I note that even Professor Fitzpatrick allowed for the possibility that there are some species of class actions, specifically, I think, the kind of no-injury consumer cases that I'm talking about now, that are not working efficiently or appropriately. I do agree with that. And I think that superiority and due process, those defenses can be used to rein in this problem. Insofar as superiority is concerned, the plain language of Rule 23b3 says that courts should consider whether certification would be fair to the parties and desirable or undesirable as a matter of public policy. The advisory committee notes are the same. They explain that certification is improper if it means sacrificing procedural fairness or bringing about other undesirable results. We can have an interesting philosophical discussion about when it is fair and just to certify a class, but it won't surprise you to hear that, in my view, a case like the Lesotho versus Mamma Mia case just isn't it. Now, the courts are all over the map on these issues, unfortunately. At some point, the Supreme Court, I think, is going to have to step in and provide some clarity one way or the other. Some courts have found that a per violation amount of damages, that's the focus. So in a TCPA case, $500, if that amount is fair on a one-time violation basis, then there's no harm or real problem in those courts' view of simply multiplying that number by the number of violations. I think the problem analytically with that is that statutory damages really are not an attempt to approximate actual damages. Rather, they are an attempt to encourage individual plaintiffs to pursue individual claims, oftentimes in small claims court. So aggregating damages in a class action is something else entirely. Other courts recognize that this is a problem, or at least potentially a problem, but they nevertheless will certify a class because they view due process and things like it as being better addressed after a judgment has been entered. The obvious problem with that is that it's incredibly inefficient to hold a class-wide trial if at the end of that trial, the court is going to enter judgment and then find that it shouldn't have done any of that in the first place because it all violates due process. The less obvious problem with that is that that trial probably isn't going to happen in the first place, and this issue is going to evade review because there are very few defendants, maybe no defendants, that are going to be willing to roll the dice at a class-wide trial when the damages can reach in the hundreds of millions or potentially billions of dollars. So those are my comments on no injury class actions, and I think with that, I will turn it over to Eric.
Go ahead, Eric.
Great, thank you. So my topic is slightly different from, though related to the topics of David and Michael. I would say that my topic has more to do with a no harm or no injury defense, as opposed to a no harm or no injury plaintiff. And in particular, I'm going to answer the question, is it a problem for class certification in an antitrust case if the plaintiff's evidence can't show 100% or near 100% of the class suffered injury as a result of the challenge conduct? And I'll answer that no and give three main reasons. The first reason is that defendants are not prejudiced in these kinds of antitrust cases by the presence of uninjured class members. And this is why I call it the no injury or no harm defense, or the due process in the air defense. In the typical antitrust case, damages are computed in the aggregate. Plaintiffs' experts will use a regression or a benchmark to show that prices were artificially inflated by a certain percentage. So for instance, a regression will show that prices were inflated on a specified number of transactions by, say, 10%, and the damages to the class will be, say, 100 million. In most cases, defendants argue that even if that number is correct in the aggregate, unless plaintiffs can show that all or nearly all of the class members paid some share of that overcharge, plaintiffs cannot show common impact and thus cannot establish predominance under Rule 23b3. One thing should be perfectly clear from this all too typical example. Whether the share of the class that suffers injury is 95% or 99% or 100% will not increase defendants' exposure to damages by 1 penny. Defendants therefore have no actual interests at stake when there are uninjured entities in most antitrust classes. That's why I call it a no injury defense, or a due process in the air defense. In fact, because of the way some regressions work, when you look under the hood, there are sometimes some entities that appear to be benefiting from the challenge conduct. And when you take those entities that may have negative damages out of the class, the aggregate number goes up. So removing quote unquote uninjured class members in this example would increase the exposure of the defendants to liability. So thus the first point I'm making is that defendants have no tangible interests in removing uninjured parties from a class. The second point I want to make is that there's no substantive requirement that plaintiffs show that each and every class member suffered impact in an antitrust class action at trial. Well, how do we know this? Well, first, I've taken a look at verdict forms in antitrust cases. And the way that those verdict forms read is they ask juries to find whether the antitrust laws were violated, whether the class, quote unquote, suffered injury, or whether the named plaintiffs did, and to assess damages. Juries are not asked whether each and every class member suffered injury. So juries just aren't asked that question. So given that uninjured persons and entities are not contributing to overall damages, the presence of uninjured class members also presents no Rules Enabling Act violation. Defendants would be exposed to the same amount of damages whether the case was brought as a class or through joinder of hundreds and thousands of individual actions. Class plaintiffs would not be using the federal rules to expand any substantive rights, and thus the Rules Enabling Act is not implicated. In addition, the Supreme Court in Tyson Foods, in fact, upheld the certification of a class that the court recognized contained uninjured members. It held simply that uninjured members could be excluded post-trial during the allocation phase when defendants no longer have any tangible interests at stake. So I'd like to raise a polling question. and let me set out the facts and then we can put up the question. Here's the question for the skeptics in the audience. Consider a summary judgment motion filed by defendants in an antitrust case with the following stipulated, meaning agreed facts. 1, defendants conspired to fix prices and allocate markets in per se violation of the Sherman Act. 2, again, this is agreed. Defendants' conspiracy caused $1 billion in overcharge damages to a class composed entirely of small business owners struggling to get by. 3rd, all but 10 of the 100,000 class members suffered antitrust injury, meaning there's 10 uninjured and the rest are injured. And assume that the 10 uninjured class members do not contribute to the aggregate damages amount. And again, assume all this has been stipulated to. So if proving 100% of the class was harmed was a substantive element of the class's claim, then in theory, this is a slam dunk summary judgment motion for the defendant. So the question is, who in our internet audience or on the panel thinks that defendants would win that summary judgment motion or should win that summary judgment motion? And then secondarily, does your answer depend on whether the 10 uninjured members can be identified and then removed from the class before trial? So is that a winner or not is the poll question. All right, and it looks like most people think that, the vast majority of you think that that is not a winning summary judgment motion. But we can talk about that. Some of you do. So some of you apparently believe that there is a substantive requirement as a matter of law that 100% of the class suffer harm. The third point I want to make about why uninjured class members are not a problem, and I'll be brief on this, is that it's unlikely even to come up at trial, let alone predominate. Many courts recognize that the predominance inquiry under 23b3 effectively asks the court to predict what the trial will be like. Will common issues predominate at trial, or will individual issues? You know, does it make sense to try this as a common in a common single trial or in individual actions? And given that there's no substantive common impact requirement at trial, it's really unlikely that this issue will even come up at trial. The plaintiffs will show that the defendant did it, they engaged in a conspiracy, that it harmed the named plaintiffs, that it raised prices above competitive levels, and that there were damages. And the defendants will say, no, they did not do it. It harmed no one. And there are no damages, or if there are damages, they're far less than what the plaintiffs say they are. That's what the trial is going to be like. There's no strategic reason either for the plaintiffs or the defendants to say, yeah, for a defendant to say, yeah, we did it, that's right. And yeah, the damages are 100 billion, but only 90% of the class suffered harm. Defendants aren't going to argue that. And so it's not an issue at trial. And so it's never going to be an issue that predominates. So in short, uninjured class members in antitrust cases do not pose a problem for plaintiffs. And I think it's a phony issue that in our cases, there's millions of dollars and thousands of hours by economists and lawyers that are spent on this one issue that really should not, it shouldn't predominate in what we end up doing with our time. So that's all I wanted to say.
Thank you, Eric. So what I want to do now is give each panelist an opportunity perhaps to respond to something another panelist said, or follow up with an additional point that was stimulated by the comments of the other panelists. So David, why don't you go ahead?
Thank you. Yeah, no, this has been a fascinating conversation, especially to see some of the perspectives that Eric's able to bring in, because my own perspective is dominated by a particular narrow stripe of this field, and seeing how these different no injury issues play out in different types of cases is sometimes eye-opening. There's such a weirdness to the TCPA world. It's such a particularized approach to litigation that sometimes it's like its own little Galapagos island in litigation. Things are different there. But aside from that, I didn't really have any challenge to the comments that either Michael or Eric provided.
Okay, so let me go to Michael.
So I guess the one thing I would maybe push back on a little bit is the Rules Enabling Act. And maybe I tend to oversimplify these things, but you know, the Supreme Court has said time and time again, you need an injury in fact, and we can disagree with its recent rulings on that in Spokio and elsewhere, but that is sort of the law. And the Rules Enabling Act says that you can't use the rules of procedure to either expand or diminish someone's rights. So to me, if you read those things together, I don't see how someone who does not have an injury could or should be part of a class. And then what follows from that, I think, is that if there is no way to ascertain who is and is not injured, what do you do with that situation? Do you certify that class at all? It won't surprise Eric, I'm sure, to hear that I'm of the view that if you can't identify the people who have and haven't been injured, then maybe that's not a case that should be certified for class treatment. I'm sure Eric has a different view, but that's sort of where I come at that problem from.
So Eric, let you respond.
Sure, those are good points. I guess what I would say is two things. First, I think that in most direct purchaser cases, it is indeed possible using the plaintiff's methodology to identify and then remove the supposedly uninjured class members. So that, and given that they are not contributing to damages or maybe reducing damages, I don't think that really becomes an issue. But you could, in theory, remove them before certification, or remove them after certification, or remove them after trial, or remove them before any of them recover any damages as a result of the case. Keeping them in there and then making sure they don't recover damages, I don't think would violate the Rules Enabling Act, even as Michael stated it. And then secondly, you have this issue of what if you cannot identify them, right? You know that, say, 90% of the class suffered injury, 10% did not, and those 10% are not contributing to damages, but you cannot identify them. First, I think Tyson Foods recognized that you can indeed certify that class, but then also said you have to come up with some kind of way to make sure that those 10% uninjured do not recover. And I think that can be done in all kinds of ways in an allocation process after the trial or after a settlement. You can ask class members to submit declarations or affidavits, for example, to provide whether or not they would have been injured under the circumstances of the case. So I think there's a lot of ways to resolve that question to ensure that uninjured class members don't recover. The last thing I would say is uninjured people recover all the time in civil litigation. It's not unusual that defendant will settle a case and the plaintiff, a case that it does not think is legitimate because they have other reasons to settle a case. And so class cases are settled all the time. Uninjured people recover all the time. A defendant will want global peace and therefore will see it as valuable to them not to exclude supposedly uninjured people because it wants a release from those people. And so they're willing to pay for that release. And that happens in private litigation outside of the class context. And I don't see why it would be a problem to have that happen inside the class context, especially in settlements.
So we have a question that came in for Michael. Michael, I don't know if you can see the question or not. It has to do with looking at the problem from the point of view that you have a large number of putative class members and that a relatively small percentage of them are uninjured. But what I'd like you to do, Michael, is respond to this question. And then also, Eric, I want you to respond to the question of, well, what do you do if, for example, and this is what I do as an economist all the time. I have to look at the alleged, the allegations and the various facts and try and figure out whether or not there is a reasonable pathway by which people are injured from the alleged conduct. And what do you do when you, for example, start to see that maybe 60% of the people are uninjured? I mean, we're talking about tiny percentages here, but there are many cases where through the analysis, you establish that a high percentage of the proposed class members may not be injured, that has not been demonstrated by the plaintiff. So, Michael, you've got tiny percentage are uninjured, and then Eric, I want you to address that you've got a large percentage uninjured. Go ahead.
Right. So the question sort of puts the rabbit in the hat. I think most courts, as I understand it, would find that if there is an extraordinarily small percentage of people who have been uninjured, then they're going to kind of look the other way and certify that class. And I understand as a prudential and policy matter why a court would do that. But I do think the reality is, at least in the cases that I generally handle, I don't do antitrust cases, I do consumer cases. In those sorts of cases where you have maybe a very small percentage of products in which a defect has manifested, but then the overwhelming percentage of people have not, right? They bought their widget, the widget worked fine, they got exactly what they paid for, and there's really no way to tell who did and didn't get the widget that malfunctioned. What do you do with that case? And I just don't think in that sort of a situation, certification is appropriate. Where do you draw the line? It's a great question, and I'm not sure I have a great answer to it. And I think it's just it's going to depend on the facts of each case.
Okay, Eric.
So just to address the last point, in a product liability kind of case, I think it's usually the case that that including supposedly uninjured people in the class will probably increase damages, as it does in the TCPA case, which is why I would, and the exposure of the defendant to damages. If you include people in the class for quote unquote being uninjured, that probably will increase damages. That's not the case in the kinds of antitrust cases I'm talking about. So let me address the 60% uninjured. Let's say that the evidence is that only 40% of the class suffered injury. And I guess assume also that you cannot remove the 60%, right? So we don't know which of the 40% are injured and which of the part of the class are uninjured, and we just have no way of determining. So a couple of things. Number one, notice that the total number of damages are the same. So it's not clear to me what interest the defendant has, whether on whether or not whether or not the class is certified or not. But I guess what I would say is if you get to a point where there's more uninjured than injured, then you may have a problem with your class definition, and you may have a problem with superiority. Is it really superior at that point to try this case with the class definition when the majority of the members of the class you're acknowledging or agreeing are not injured? So that is potentially a superiority problem, and you could handle it in a under superiority. But once you get above 60% injured and you acknowledge that the uninjured are not contributing, and you believe you can come up with a way after trial or after settlement to make sure that the uninjured receive a nominal amount or don't receive damages, receive some amount maybe to give a release, but don't receive more than that, then I think that would be perfectly fine. I think just to respond to one of the things that Michael said, it seems to me that a lot of the concern with the TCPA cases expressed both by David and Michael have more to do with concern about the statute itself and what the statute implies than class certification. And it seems to me that that those substantive objections to the statute, right? It's providing a statutory amount of damages even where the defendant did not intend, may not even have known, and may not have caused any harm, right? That might be a problem with the statute, and maybe the idea is you should go to Congress and have the statute amended, but it doesn't seem to me to be a question related. It doesn't seem to be a Rule 23 question. It seems to me to be a question about amending the statute or changing the statute to avoid these potentially unintended consequences of the statute.
So I want to go to David maybe as a follow-up with that, because David had explained that the Biometric Information Privacy Act and the California Invasion of Privacy Act treats the violations, the statutory violations are treated as injuries in fact, but this is not true with other laws. So David, can you follow up on that, the distinction?
Yeah. And this responds in part to something that Eric just addressed. And some of these laws apply statutory damages at the thresholds that they do because the legislatures are looking to individual plaintiffs to serve in that enforcement capacity. I know that was part of the logic that the Illinois legislature had behind the Biometric Information Privacy Act, was rather than expecting our essentially bankrupt government to do all of the necessary policing to hold corporations in line about how they handle biometrics, that by providing somewhat catastrophic statutory damages to individual plaintiffs, that you would then incent companies to be compliant without necessarily having to have that enforcement action. So I'm not sure how effective it is to say that the solution is to go to legislatures and have the laws rewritten, because they were written in the way that they are for a particular purpose, but then it has the side effect of creating an environment where aggregated class actions can be extraordinarily valuable, extraordinary damages against defendants for actions that didn't necessarily manifest any concrete harm. So specific to the biometric case in the California invasion of privacy case, what's going on there is you've got this trick to the effect that what counts, or what the legislatures are thinking of as an injury, isn't necessarily an immediate economic loss to the harmed party. That rather than being able to measure some money that you have that's been cost to you, or that you had failed to get because of what's happened, the idea is that these data privacy laws are trying to protect your interests in something where, if there were a data breach, that could have catastrophic consequences to you as a consumer, that would be very difficult to remedy. For example, with biometrics, the phrase that the plaintiffs often use there is, you can change your password, but you can't change your fingerprints. Now, as a technologist, I think that's a very misleading statement. I've written about that before. If that's something you want to follow up on, please seek out my articles. I don't want to go down that path right now. But let's take it at face value. If that's the argument that you're making, the exposure of someone's fingerprints, or the potential exposure of those fingerprints, represents something that is going to be very difficult to remedy. So that's why the legislatures treat those as an injury, in fact, even if there's no immediate concrete harm to the exposed party.
Can I just respond to that briefly?
You absolutely can.
It seems to me, again, that David's points are good, but they're still objecting to the statute itself, right? He's assuming that the legislature wasn't aware of the Rule 23 in the federal rules, or the corresponding rule under state law. And I think you'd have to assume that they are aware of that. But even if you assume that they were not aware of the procedural devices available to plaintiffs with private rights of action, you're again suggesting that the legislature go back and rewrite the statute and say that for these particular claims, aggregated relief under the relevant laws are not appropriate or not allowed. So I think there are ways that a legislature has to limit the use of procedural devices. I think, though, I know that there are some Supreme Court cases on that point, and I can't recite them all, but it does seem to me to be still fighting with the statute. One other point I would make is that it seems to me that this question of no injury and no injury class actions actually assumes the conclusion. It seems to me that a legislature has the ability to create a right that individuals have, and then create a remedy for that right, and that remedy can include a private right of action and statutory damages. And when you create a right and that right has been violated, you've been injured, whether or not you lost money or somebody hit you on the head. So I don't agree really that these are no injury class actions. The legislature has created a right. Maybe it's too broad, and maybe the right needs to be, or the remedy needs to be limited in certain circumstances, but I don't see them as no injury at all.
So you would say, can I just follow up on that? So you would say that because they had understood there's Rule 23, and they then passed a law that gave people certain rights, that they fully anticipated that those injuries would satisfy the existing framework. So therefore, if you don't like that, you have to go back to the new laws that are giving these people rights, as opposed to look at the Rule 23 procedures and hope that the analysis will be done and people will get down to the micro degree of showing whether or not somebody was really affected or not affected.
I think that you'd have to assume that the legislature is aware of the various procedural devices that private litigants have. And if you think they made a mistake, go back to the legislature and ask them to rewrite the statute.
So if I could just respond to that this discussion briefly. I mean, to me, it is a TCPA problem, but it's not just a TCPA problem. This is a BIPA problem. This is a Fiegre problem. This is any statute that provides for uncapped statutory damages. It has the potential to be invoked in a way that will provide for annihilating statutory damages. And then the question becomes, what do you do about that? There are certainly some courts, the Ninth Circuit and the Seventh Circuit are in this camp, that they say, well, as Eric said, Congress could have done otherwise. They could have capped damages and they didn't. And to use Rule 23 to do that would be to subvert the statute. And I understand that line of thinking. Respectfully, though, I think it's wrong for the reason I think Eric said. I think Congress does operate with the assumption, we assume that Congress drafts statutes with knowledge of the rules of procedure. The rules of procedure have provided for a very long time that superiority is something that should be considered when you certify a class. There are cases going back to the early 1970s. The Ratner decision from Judge Frankel's 72 decision, I think, does exactly that. It refused to certify a class because of the potentially annihilating aggregate damages provided in essentially a no injury case. So to me, it's not subverting the statute to consider these things when you're deciding whether to certify a class. It's doing exactly what judges are supposed to do as gatekeepers in the certification process. They consider all of the equities and the facts and they make their decisions. I think, you know, courts are not really just calculators. They're not supposed to just multiply the number of violations by the number of statutory damages, and that's the judgment. They really should be doing more than that. And many courts are willing to make those analyses, but some are not yet.
Let me just respond to that if you don't mind. It seems to me that your definition of superiority is not the way I read superiority, put it that way. Superiority, what you're saying is that superiority means that it's superior to use the class mechanism than individual mechanism to enforce the statute, the law, the right at issue. And what you're saying is it's not superior in certain cases because this would enforce the law too well. And I just don't think that it's the judge's role to decide that Congress made a mistake and that if we actually enforce the law as written to the maximum extent, that would be unfair to the defendant. That's just not a judge's role. A judge's role is to decide, especially at Rule 23 stage, is to decide whether it makes more sense to try this case, makes more sense from a prudential basis to try this case as a class or as an individual, which is the best way to enforce this law. Does it make sense to have thousands of individual claims, or does it make sense to do it all at once? And not, is it unfair to the defendant if the law is enforced to the maximal extent?
Yeah, I think that's just where we're going to have to agree to disagree. I think the superiority prong is about more than just efficiency. It is, I mean, it's baked into the rule is fairness and desirability. And courts for a very long time have been considering these things when certifying a class. Some courts don't, but some do. I think the latter bucket is a better approach. But eventually the Supreme Court's going to have to take these issues up, I think.
So I want to raise, first of all, we do have a question for Michael, who brings the suit for $500, and I guess pretty much nobody but would, but.
No, well, let me push back on that, because that's a common thing I hear from the plaintiff side of things. And I think there was a panel yesterday or the day before about mass arbitrations, where you have people filing arbitrations on behalf of thousands of people. I think those cases are fascinating for a lot of reasons, but one of them is because it really does put the lie to that narrative. There are plenty of lawyers out there who would be happy to file a case over a $500 claim if they're going to be getting their attorney's fees for doing it. So no, I don't agree with the premise of the question at all. Okay,
but that would be a class action, and
no, those would be individual arbitrations in that case.
Right, but there are only certain categories of cases that it will make sense from a litigation perspective for someone to bring those claims. Right, there are certain claims where all of the people work for the same company and they can all be contacted and they can all be found, but there are lots of potential claims with thousands of or millions of disparate class members all across the country, and there's just no way to to aggregate all of those claims and bring them in a way that would be at all efficient. I mean, the mass arbitration is extremely inefficient for both sides, right? It costs millions of dollars and it doesn't make any sense. Compared to doing it on a class-wide basis, the only reason they're done is because companies have put class action bans and arbitration clauses forced in contracts that people have to sign to do business with the defendant.
So I wanted to go back to something that you said, Eric, about the distinction between the TCPA type cases and some of the other areas. So it seemed like you were distinguishing, where you have statutory damages, then you have antitrust damages, and then you might have things like the product liability or misrepresentation or omissions, those kinds of damages. And in those matters now, many times you find that the plaintiffs have essentially moved the framework from the typical product liability framework, for example, more to a breach of contract framework, and where you have the benefit of the bargain approach, and that the consumer has not received the worth of the product being purchased. And when you have that, that's basically an overcharge model. That is an overcharge model. And so there, what you do find is that even if you have a small percentage of the consumers feel like they overpaid for a particular product, you're doing the same sort of benchmarking and that type of analysis that you could argue, well, then these uninjured people, they are not going to move that demand curve around enough to affect the damages. You could argue that. But on the other hand, in those matters, very often the analysis is all about the cohesiveness of the proposed class members. And if you find that most of the class members, they buy the product, they like the product, they use the product, the whatever's apparently or alleged to be wrong with the product doesn't really affect their willingness to pay for the product, just having a small number of plaintiffs where it does affect their willingness to pay, because it works out in the averages again, that will lead to a damage amount, even though the majority of the class members are apparently uninjured. So I was going to ask, does anybody want to respond to that? Because that seems to be something that is relatively new in a lot of these, in a lot of this litigation, is to take that benefit of the bargain approach.
Yeah, I mean, I guess it depends a lot on what the facts actually are, but if a defendant misled the marketplace about what a product does, whether you bought the product and are happy with it is sort of besides the point, because the argument, I guess, would be if they hadn't misled the market about what the product does, the product would cost less for everyone, right? If you say your product has some super duper advantages over its rival, and so we can charge an extra 25% because of these super duper advantages that you've touted to the public, and turns out those super duper advantages are just lies, then everybody's overpaid by 25%, and that it doesn't matter whether you like the product or not. You still overpaid. It doesn't matter if you would freely buy the product at that higher price, because obviously everyone freely bought the product at the higher price. And every price fixing case, every buyer freely bought the product at the artificially inflated price. So the fact that you freely bought the product isn't really relevant. The question is, absent the price fixing in an antitrust case, or absent the fraud in this kind of benefit of the bargain case, was the price artificially inflated? And if it was, then everyone's injured. So I think that's why they're framed that way, right? Because then you can get a common impact argument out of a case that otherwise would look very individualized.
Okay, so I see that we are down to just before the next panel is supposed to start. I want to thank my panelists, David and Michael and Eric. Thank you so much. I thought this was a great discussion. It shows there really is still remaining a lot of diversity in the thinking here, and it's been a real pleasure to have all of you and share that with the audience. So Chris.
Thank you. And Robin, Eric, Mike, and David, thank you for that discussion about no injury class actions. There has been a lot of debate about this topic, and that was a provocative panel to start our day.